H1B Guy here, and today, the H1B Guy news for the week ending December 18th, 2020. But before we get started, I'd like to ask you, if you haven't already, to please subscribe to the H1B Guy channel here on YouTube. It helps me to produce more content like this for you. I also wanted to mention the H1B Guy offers a variety of consulting services. If I can provide you peace of mind by helping you bridge the gap between your employer and your immigration attorney, please reach out. I'd love to hear how I can help you. Today's news is brought to you by RecruiterNetworks.com, the smart solution for digital perm ads since 2001. I wanted to give one last big thank you to Deepu Asak for joining me yesterday on the H1B Guy Live Stamp It Out 6. We discussed his immigration journey, medical engineering, creative outlets, and HR1044. Please check that out if you haven't already. I'll put a link in the description. Now, the news. December 14th, 2020, in an article written by Fred Bauer for the National Review titled How to Paralyze the Immigration System in One Ill-Conceived Step. Quote, the rationale behind the current effort to remove per-country caps on employment-based green cards may well be similar. If there's a problem with part of the system, break the whole system. In theory, this is meant to prevent one or two countries from monopolizing all of the visas. In practice, one country's nationals can exceed the 7% cap if visas would otherwise be left unused. For instance, Indian nationals regularly use much more than 7% of the visas in the major employment categories. Supporters of removing the caps argue that doing so would make the American immigration system more equitable, but it would also have significant structural consequences for employment-based immigration and the American economy. In essence, removing the caps would extend the waiting time for visa seekers outside India and China while not actually reducing the size of the global backlog. The Congressional Research Service raises the possibility that doing so could benefit the IT sector at the expense of other industrial sectors that are also critical to the United States. In other words, it could help the tech sector clear its green card backlog, but it might also hamper the ability of other kinds of employers to recruit immigrants with employment-based visas. Universities, pharmaceutical companies, the art and entertainment industries, and other economic sectors might face new struggles recruiting talent abroad because the global employment-based green card backlog for other countries and other economic sectors would be much longer. Inviting crisis in order to encourage reform would be risky. Immigration politics are so contentious that there's no guarantee reforms would actually materialize. And if they don't, a sustained global green card backlog could further incentivize the use of guest worker programs. As over 1 million individuals anxiously await an update on HR 1044, with only today left for session unless another extension of Congress occurs. If this extension happens, it could be through December 31st, 2020, but some are reporting next week. I just don't agree that they'll only extend until Christmas. The COVID relief bill and omnibus bill both hang in the balance. Something has to happen. January 3rd is the date to mark. Once that day is come and gone, only then will the fate of HR 1044 and S386 be determined. I wanted to cover this article for several reasons. It paints a completely different picture of the Fairness for High-Skilled Immigrants Act. There's no denying there is a cause and effect to any change of any existing law. I'm willing to bet that many of you watching this disagree with pretty much every point this article makes. As I've stated many times, I disagree with a quota based on country of origin for employment-based preferences, specifically high-skilled. This article goes as far to call it a theory. As I covered on Monday in the H1B Guy Views how employers, consulting, and staffing firms benefit from HR 1044 S386, they have a lot to gain by its passing, as do over 1 million individuals. Regardless of what happens with HR 1044 S386, I'm going to be constantly talking about merit. A points-based system would solve so many problems that exist with the current system. You come to this channel for an honest opinion, and I'm always going to cover both sides. December 15th, 2020, in an article written by Luban Kavli for the Times of India titled Trump Admin Loses Third Lawsuit Against Imposition of Wage Hike for H1B Holder. Quote, a bunch of U.S. universities and nonprofits have emerged victorious in a lawsuit filed by them against an interim final rule. 17 plaintiffs, which included Purdue University, University of Michigan, University of Denver, Chapman University, Bard College, Arizona State University, Indiana University, and a few nonprofits, had filed this lawsuit with the U.S. District Court of Columbia. They were represented pro bono by the American Immigration Lawyers Association, AILA, and prominent immigration attorneys. In all three lawsuits filed against DOL's interim final rule, the verdict has gone in favor of the plaintiffs, be it by way of the rule being set aside for a preliminary injunction being granted. In all three cases, the U.S. district courts have held that not by allowing for a notice and comment period before publishing the interim final rule, the DOL has denied the plaintiffs and the public in general these important protections. In this case, Judge Emmett G. Sullivan held that the DOL did not sufficiently justify its prediction that advance notice and comment procedures would have been contrary to the public interest. In any event, the DOL has failed to provide an evidence in the record supporting its prediction there would be a massive rush to evade the interim final rule. If the DOL had provided advance notice and comment, state the order issued on December 14th. Judge Sullivan went a step further than the earlier orders of the two district courts. He's ordered the DOL to reissue all wage determinations issued after October 8 under the now invalidated law. However, the fall agenda issued recently by the DOL contains a proposal to shortly introduce the wage hike rule as a final rule. This can be done by curing the defect of not vetting public comments before implementation, which was the basis for the interim final rule being set aside by the district courts. Yet again, another loss for President Trump's administration in court in an immigration case. Of course, this one comes as no surprise, but there are two very interesting points made in this article. The first one is Judge Sullivan's ordering of a reissue of all wage rulings after October 8th. If you recall back on the H1B Guy news for the week ending December 4th, 2020, where we closed with the DOL's announcement on the IFR per Judge White's orders, and that the DOL stated that they were going to use wages between October 7th and December 15th under the new wage. Now, that has been completely overturned by Judge Sullivan, and all LCAs are now to be based upon the prior wage levels. Then the article closes with a point that cannot be missed. Quote, a proposal to shortly introduce the wage hike as a final rule. President Trump's administration is no doubt hell-bent on increasing the wage levels before exiting office. As I alluded to yesterday on the H1B Guy Live Stamp It Out 6, this would be one final gut punch for the H1B temporary foreign worker. If they are trying to get this done before January 20th, we would have to have a notice in the next few days. December 16th, 2020, in an article written by Tom Price for the Washington Examiner titled, Congress Can Fix the Shortage of Healthcare Workers. Quote, with pandemic fatigue wearing on the nation's health and mental welfare, many have become desensitized to the troubling statistics that worsen by the day. And while many of us are understandably complacent during the pandemic, that doesn't mean the staffing shortage and workload crisis currently facing healthcare professionals has gone away. The bipartisan Healthcare Workforce Resilient Act, introduced by Senators David Perdue and Dick Durbin, would reallocate unused visas from previous fiscal years to give highly skilled foreign-born nurses and doctors, giving them the opportunity to work in our country and help solve the crisis. It would reclaim 25,000 unused visas for nurses and 15,000 unused visas for doctors, exempting these visas from contributing toward any limits or caps on any country of origin. It also ensures that immigrants receiving these visas do not displace U.S. workers and requires the Department of Homeland Security and the State Department to expedite the processing of recovered visas. Before the pandemic, researchers at the Association of American Medical Colleges found that America could face a gap of as many 139,000 physicians by 2033. Shortages of registered nurses have also been a long running problem, especially in nursing homes, three-fourths of which faced staffing shortages prior to the pandemic. Congress must do everything in its power to pass any innovative solution to the nation's pressing and complex healthcare crisis. Passing the Healthcare Workforce Resilient Act as part of the federal relief package would prove our representatives' commitment to serving our first responders and will save countless lives. Tom Price is a former congressman from here in Georgia who was an MD prior to taking public office. Of course, he served in President Trump's cabinet. Earlier this week, it was reported that S3599 was not going to be included as part of the COVID relief bill. I've covered S3599 a few times during the H1B Guy breaks down Senate Bill S3599, Healthcare Workforce Resilient Act, and the H1B Guy reveals the anxiety of H1B medical professionals and why S3599 is vital. Something has to give as it relates to MDs, RNs, and even PTs. I talk about the war on human capital all the time. This time, it is all about the medical professionals. A shortage of over 139,000 physicians by year 2033 is a scary thought. It isn't the major metro areas that will suffer, but rural America when it comes to this kind of shortage. Let's hope that doesn't become a reality. For the full post on the H1B Guy news for the week ending December 18th, 2020, please check out the H1BGuy.com. I wanted to go ahead and plug next Wednesday, the H1B Guy Live Stamp It Out 7 with Dr. Raj Karnatak at 2 p.m. Eastern. You don't want to miss this one. A reminder that today's news was brought to you by RecruiterNetworks.com, the smart solution for digital perm ads since 2001. This national job board network provides recruitment websites in 1,024 major U.S. metro areas. Each local job board is its own portal and is a low-cost resource for immigration recruitment ads for all industries and professions with a flat price of $225 per ad, regardless of which city you choose. RecruiterNetworks.com has been the number one place for immigration attorneys, immigration ad agencies, and employers to meet the DOL requirements for the digital portion of the perm advertisement rules. RecruiterNetworks.com. Tell them the H1B Guy sent you. If you haven't already, I'd like to ask you to please like this video. Please subscribe to the H1B Guy channel here on YouTube and click the bell for notifications so that you're notified anytime we post a new video here to this channel or we go live like we will next Wednesday with Dr. Raj Karnatak. If you've made it this far, I just want to say thank you for taking the time to watch my content. I really appreciate your support. The H1B Guy, your global source for all things H1B.